In 1987, Harold Benton got a letter saying he'd lost 14 acres. Not to a drought, not to debt, not to the farm crisis that had already taken half his neighbors. A licensed surveyor hired by the man who owned the land to his north had filed a document with the county saying that the iron stake marking Harold's boundary, the one his great-great-great-grandfather had driven into limestone in 1847, could not be found. One document, one corrupt surveyor, and a scheme that had been quietly moving property lines across the entire county for 3 years. Harold went out that night with a flashlight. The stake was there. It had always been there. And what happened next would take 6 years, 2 attorneys, a federal investigation, and 140 years of handwritten records to prove it. The survey stake had been in the ground since 1847. Harold Benton knew this because his grandfather had told him, and his grandfather's grandfather had placed it there, a square iron rod, 3/4 of an inch across and 30 inches long, driven into the limestone shelf at the northwest corner of the Benton ground with a sledgehammer by a man named Cyrus Benton, who had come to Calhoun County from Ohio in 1844 with a wagon, a wife, a Bible, and $160 in silver coin. Cyrus had filed his claim at the land office in Hardin on a Tuesday morning in September of 1847, paid the government price of $1.25 per acre for 120 acres of river-bottom ground along the Illinois River, and driven his survey stake before the week was out. The stake was still there in the spring of 1987, when Harold Benton walked the fence line for what he estimated was the 400th time in his 61 years on the property. It had settled somewhat over 140 years, the ground around it had heaved through 1,000 freeze-thaw cycles, and the stake now stood perhaps 18 inches above the soil rather than the original 24. But it was there, and it was iron, and it had not moved. Harold knew this because he had measured from it himself 3 times in his life. Once at 22 when he took over the farm from his father, once at 40 when the county reassessed the property boundaries for the new tax maps, and once at 58 when his neighbor to the north, a man named Gerald Purvis, had suggested politely, carefully, in the way that a man suggests something he knows is wrong, but hopes you won't notice that the fence line between the Benton and Purvis properties might be a few feet off, and that perhaps a new survey would clarify things. Harold had not hired a surveyor at 58. He had gone out to the northwest corner stake, measured from it with a steel tape to the northeast corner stake, found the distance to be exactly what the original plat showed, 2,640 feet, a half-mile, as it had always been, and told Gerald Purvis that the fence line was exactly where it had always been, and that he was welcome to hire his own surveyor if he disagreed. Gerald Purvis had not hired a surveyor. Now it was 1987, and Harold was 61, and Gerald Purvis was dead, and Gerald's son Raymond had inherited the Purvis farm and the Purvis disposition, which was to say, a talent for acquiring things that belonged to other people while maintaining an expression of complete innocence. And the survey stake at the northwest corner of the Benton ground was about to become the most important piece of iron in Calhoun County. Harold Benton was not, by any measure that the modern agricultural world would recognize, a large operator. He farmed 240 acres, he had no employees and no debt, which in 1987 was a more unusual combination than it had been in 1957. The farm crisis of the early 1980s had destroyed a significant fraction of the farming operations in Calhoun County farms that had borrowed heavily in the 1970s when land prices were rising and commodity prices were strong, then found themselves in the early 1980s with land values falling and interest rates at 18% and grain prices that didn't cover the cost of production. Harold had watched his neighbors go through the auctions and the foreclosures and the quiet departures, and he had not been among them because he had never borrowed what he couldn't repay and had never expanded beyond what the land could support without leverage. His father had told him this, and his father's father before that, and it was a principle so deeply embedded in Harold Benton's understanding of farming that he could not have told you where the principle ended and the man began. The 240 acres produced corn and soybeans in a rotation that Harold had maintained since 1962. Corn one year, soybeans the next, back to corn, with a small patch of 40 acres along the river that he kept in permanent grass cover for hay and pasture for the 12 beef cattle he ran as a secondary enterprise. The equipment was old and maintained. A 1,969 John Deere 4020 tractor with a rebuilt engine that Harold had done himself in 1981. A 1,974 International 1,480 combine that he had purchased used in 1979 for $14,000 and kept in a condition that a dealer would have called remarkable for its age, and an assortment of tillage and planting equipment that averaged perhaps 20 years old, and that Harold kept running with the same philosophy he applied to everything. Mechanical, understand it completely, maintain it before it fails, and keep parts for the pieces most likely to wear. He lived in the farmhouse his grandfather had built in 1908, a 2-story white frame house with a wraparound porch and a root cellar, and a well that produced cold, clean water from a limestone aquifer 60 feet below the yard. His wife Dorothy had died in 1979. His son Thomas had grown up on the farm, left for the University of Illinois in 1978, stayed in Champaign with an engineering degree and a job at Caterpillar, and came home for Christmas and 1 week in August and called every Sunday. Harold did not resent Thomas for leaving. The farm could support one man adequately. It could not support 2 families, and Thomas had made a life that suited him. Harold's life suited him too. He had no GPS, he had no computer, he had no yield mapping system or precision agriculture software or satellite-guided planting prescriptions. What he had was 240 acres of river-bottom ground that he had walked every growing season for 40 years, a set of hand tools and steel tapes, and a surveyor's transit that had belonged to his father, 3 decades of handwritten notebooks recording observations of his property, and an understanding of that ground so complete that it lived not just in his memory but in his hands, in his feet, in the way he could tell by the feel of the soil whether the drainage tile was working correctly or whether a wet spot in the northeast corner of the east field meant the tile had collapsed again at the junction point 30 feet below the surface. He did not think of this knowledge as remarkable. It was simply what farming was. The only thing that had not suited Harold Benton, in the spring of 1987, was the letter he had received from the Calhoun County Assessor's office on a Thursday in April, informing him that his property tax assessment for the coming year was being adjusted based on a boundary revision, and that his taxable acreage was being reduced from 240 acres to 226, 14 acres. Harold read the letter 3 times, standing at the kitchen table with his coffee cup in his hand, and then he set it down and went to his filing cabinet and found the folder labeled Deed and Survey, and read the original survey plat from 1847, and the updated county plat from 1952, and the tax maps from 1971, and all of them said the same thing: 240 acres, bounded on the north by the Purvis property, on the east by the River Road, on the south by the Deckard Farm, and on the west by the Illinois River floodplain. He called the assessor's office the following morning. The woman who answered told him that the boundary revision had been made based on a survey commissioned by an adjacent property owner. She could not tell him which adjacent property owner, which Harold found unusual, or why a survey commissioned by someone else should change his property record, which he found more unusual still. She suggested he come in to speak with the assessor. Harold drove to Hardin on Monday morning and sat across a metal desk from a man named Douglas Crane, who had been the Calhoun County Assessor for 11 years and who wore a short-sleeved dress shirt and kept a calculator on his desk next to a framed photograph of a boat. "Mr. Benton," Douglas Crane said, "I understand your concern, but the survey is the survey. If the boundary has been re-established by a licensed surveyor, the county has to reflect that in the tax records." "Who commissioned the survey?" Harold said. Crane looked at his desk. "I'm not sure I'm at liberty to. It's my property line," Harold said. "I have a right to know who is claiming my ground." Crane was quiet for a moment. Then he said, "Raymond Purvis commissioned it." Harold said nothing for a long moment. He looked at the framed photograph of the boat. "And the surveyor said the line moved 14 acres onto the Purvis side," Harold said. "The survey indicates that the original fence line was placed approximately 70 feet south of the actual legal boundary," Crane said, "which would mean approximately 14 acres of what you've been farming, as your ground is actually what I've been farming as my ground since 1847, Harold said, "and what my grandfather farmed before me and his grandfather before him." "Mr. Benton, I understand this is. Do you have a copy of the survey?" Harold said. Crane produced it. Harold took it, folded it, put it in his shirt pocket, thanked Douglas Crane for his time, and drove home. He sat at the kitchen table that evening with the survey spread out in front of him and his own plat documents beside it and a measuring tape and a legal pad, and he studied what Raymond Purvis's licensed surveyor had done. The surveyor, a man named Philip Aldrich from Jerseyville, whose name appeared on the survey document, had established a new northwest corner point for the Benton property that was 71 feet south of the original survey stake. His basis for this, as stated in the survey notes, was a recovered monument that he described as a concrete boundary marker located at a point consistent with his proposed new boundary. The original iron stake, according to Aldrich's notes, was not located. Harold read that phrase, "not located," and put his finger on it and kept it there for a long time. Then he put on his boots and went out to the northwest corner of his property in the dark with a flashlight. The iron stake was exactly where it had always been. Raymond Purvis was 44 years old in 1987, and he had come to the Purvis farm not by working it but by inheriting it from a father he had not respected and a family tradition he had not much valued. He lived in St. Louis, where he worked in commercial real estate, and he came to Calhoun County 3 or 4 times a year to check on the farm, which was rented to a tenant farmer named Dale Coble, who worked the ground competently and paid his rent on time and had no particular interest in boundary disputes one way or the other. What Harold did not know about Raymond Purvis in the spring of 1987 was that Raymond had been in regular contact for the previous 2 years with a man named Carl Whitmore, an attorney from Jerseyville who handled real estate matters in west-central Illinois with the smooth efficiency of a man who had spent 20 years learning which county officials were susceptible to which forms of persuasion. It was Whitmore who had found Philip Aldrich, and Whitmore who had suggested to Douglas Crane that the new survey represented an opportunity to correct a long-standing discrepancy in the county records, and Whitmore, who had drafted the letters that appeared in official county envelopes suggesting to Harold Benton that his property had been reassessed. What Harold also did not know not yet was that Whitmore was the registered agent for a land development company called Riverfront Holdings, LLC, incorporated in Missouri in 1983, which had been quietly accumulating options on parcels of Calhoun County river bottom ground for 4 years. Options on parcels that happened to adjoin properties whose boundary lines had been revised by Philip Aldrich surveys. Harold would learn all of this eventually. But in the spring of 1987, what he had was a letter from the county assessor, a survey that said his iron stake did not exist, and 61 years of knowing exactly where that iron stake was. He called Thomas on Sunday. Thomas drove home from Champaign the following weekend and sat at the kitchen table with his father, and the survey documents, and the original plat, and a topographic map of the county that Harold had obtained from the USGS office years ago. For a drainage project, Thomas had an engineer's mind, methodical, precise, comfortable with spatial relationships and measurement, and the language of technical documentation. He read Philip Aldrich's survey with the focused attention of someone looking for the seam in an argument. He had been coming home every Christmas and 1 week in August for 9 years. He had never come home to something like this, something that required not the skills of a son visiting a widowed father, but the skills of an engineer confronting a problem that had been deliberately constructed to be difficult to solve. He felt, sitting at the kitchen table with the documents spread between them, a particular kind of anger that was different from ordinary anger because it was cold rather than hot, the kind of anger that focuses rather than diffuses. "He says the iron stake was not located," Thomas said. "It's there," Harold said. "I showed you when you arrived. I know it's there. I'm saying that his document says it wasn't located. That's a professional judgment, filed with the county." Thomas looked at the survey notes. "He's basing the new boundary on a concrete boundary marker that he says he recovered. Where is this marker?" "I don't know," Harold said. "I've never seen a concrete marker on that line." "Then we need to find it, or prove it shouldn't be there." Harold looked at his son. Thomas was 30 years old, with Dorothy's eyes and Harold's jaw, and the careful hands of a man who worked with precision instruments. He had not grown up expecting to defend his father's property against a fraudulent survey, but he was bringing to the task the same systematic approach he brought to engineering problems, which Harold found both reassuring and slightly heartbreaking, the sight of competence deployed against something that should not have required it. "How do we prove a boundary?" Harold said. "With evidence," Thomas said. "The oldest, most reliable evidence we can find." He pulled the original 1,847 plat toward him. "This is where we start." The Calhoun County Recorder's office was in the basement of the county courthouse in Hardin, a limestone building that had been constructed in 1889, and that smelled, in its basement, of old paper and coal dust, and the particular mustiness of documents that had been stored in the same place for generations. The fluorescent lights flickered at one end of the room, casting an uneven light across the rows of bound record books that ran from floor to ceiling on shelves built of the same lumber as the shelves in Harold's machine shed. Thomas spent 3 Saturdays in the summer of 1,987 inches that basement. He had taken unpaid leave from Caterpillar 2 weeks, which his supervisor granted with the brief reluctance of a man who values a good engineer and doesn't want to lose him over a family matter. And he worked through the record books with the methodical patience that Harold recognized as his own temperament expressed through a different generation. The recorder, a woman named Martha Gifford, who had held the position for 22 years and who regarded the record books in her care with the protectiveness of a librarian guarding rare manuscripts, watched Thomas's progress with cautious interest through the window of her office. On his second Saturday, she came out to the reading table where Thomas was working. "You're Harold Benton's boy," she said. "Yes, ma'am. Your father's a good man." She looked at the survey document he had spread on the reading table. "Philip Aldrich did that survey." "Yes, ma'am." She was quiet for a moment, arranging papers in a way that was not quite purposeless. "Philip Aldrich filed 3 surveys in this county in 1986 and 1987, she said. "All 3 moved boundary lines in directions that benefited the parties who commissioned the surveys." Thomas looked up at her. "That's the kind of information that's in the public record," Martha Gifford said, and went back to her office. Thomas wrote it down. Over 3 Saturdays, working from 8 in the morning until Martha Gifford locked the building at 5, he assembled the following documentary record. The original 1,847 Federal Land Survey establishing the Benton property, with the northwest corner monument described as an iron rod driven to the limestone. The 1,892 county plat reconfirming the same boundary. The 1,924 deed, transfer from Cyrus Benton's grandson to Harold's father, referencing the same corner monument. The 1,952 county tax map, showing the boundary in its historical location. The 1,971 reassessment, also consistent. and Harold's own deed from 1962, which included a Métis and Bounds description referencing the iron rod at the northwest corner. 140 years of continuous documentation, every piece of which described the boundary as Harold had always known it. Against this, Philip Aldrich's survey offered one piece of evidence, a recovered concrete marker at a location 71 feet south of the iron rod. Thomas also found in the deed records something that Aldrich had not mentioned in his survey notes, a 1903 deed for the Purvis property that described the southern boundary of the Purvis land as beginning at an iron rod at the northeast corner of the Benton ground, which, if the historical boundary was correct, put the Purvis southern boundary exactly where Harold's northern fence had always been. He photographed everything. Harold had a Nikon F3 camera that he had purchased in 1982 for photographing crop disease symptoms, a practical tool that had now acquired a different purpose. Thomas photographed every document at the recorder's office, every page of the original plat, every deed in the chain of title going back to 1847. He filled 4 rolls of film on the third Saturday and had them developed at the pharmacy in Hardin, and filed the prints in labeled envelopes alongside photocopies he had made at the courthouse copy machine for 25 cents a page. On the drive home from the third Saturday, Thomas said, "The concrete marker is the key. If we can show it's not original, if we can show it was placed recently, Aldrich's entire survey falls apart." "How do we show that?" Harold said. "Concrete ages. It weathers. A marker from 1847 would look completely different from a marker placed in 1985. Harold considered this. And if it was placed in 1985, then someone placed it there to support a survey that had already been planned, Thomas said, which is not a boundary dispute. That's fraud. They drove the rest of the way home in silence, the summer corn tall on both sides of the county road, the Illinois River visible in the distance as a dark line of cottonwoods against the evening sky. Harold Benton had never met a geodetic engineer. He found one through Thomas, who spent an evening calling the civil engineering department at the University of Illinois, and was referred, by 2 separate faculty members who gave the name independently, to a man named Walter Hess, a professor emeritus of geodetic engineering who had spent 30 years teaching land surveying and who occasionally took private consulting work on cases where the technical questions were interesting enough to justify his time. Thomas called Hess on a Thursday evening in July and explained the situation in the methodical way he explained things, starting with the facts, proceeding to the evidence, ending with the question. Hess listened without interrupting, and then said he would come down on the following Thursday if Harold could be available for the full day. Harold arranged for Jimmy Reese, a neighbor's boy who helped him during planting and harvest, to run the tractor that day, and met Walter Hess at the end of the driveway at 8 in the morning. Hess was 67, lean and deliberate in his movements, with the kind of weathered precision that comes from spending a career outdoors with instruments that require steadiness. He drove a pickup truck that was newer than Harold's, but similarly utilitarian, and he carried his equipment, a transit on a tripod, a steel tape, a survey rod, a metal detector, a camera, and a notebook with the ease of a man who has carried the same tools for 40 years. He spent the entire day walking the Benton property. He found the northwest corner iron stake in 40 minutes. He found it the same way Harold had always found it, by measuring from the road, right-of-way, to the established monuments at the southeast and northeast corners of the property, computing where the northwest corner had to be based on the historical survey dimensions, and going to that location and looking for iron. The metal detector confirmed the stake's presence under 3 inches of accumulated sod, and a careful removal of the sod with a flat spade revealed it. A square iron rod, 3/4 of an inch across, with the dark reddish-brown surface oxidation that iron develops after more than a century in the soil. A different color, a different texture, a different character entirely from recently rusted metal. Walter Hess photographed the stake from 6 angles before touching it, then photographed it from 6 more angles after the sod was cleared. He measured its position relative to 3 established reference points with the steel tape, recorded the measurements in his notebook, and wrote beside them, "Iron monument consistent with 1,847 Federal Survey. Location matches historical plat within 0.3 feet. Monument appears undisturbed. Surface oxidation pattern consistent with estimated age of 130 to 140 years. Then he walked 71 feet south and found the concrete marker. It was a poured concrete cylinder approximately 8 inches in diameter and 12 inches tall, with a copper cap on top stamped with a survey number. Hess crouched next to it and examined it for a long time without speaking. Harold and Thomas stood a few feet back and watched him, the way people watch a doctor examining something they cannot interpret themselves. Hess touched the concrete surface with his fingertips. He examined the base where the concrete met the soil. He took out a small magnifying glass and looked at the copper cap. He photographed the marker from multiple angles. Finally, he said, "This is not an old monument." "How can you tell?" Thomas said. Hess pointed to the concrete surface. Efflorescence, the white mineral deposits that form as calcium carbonate migrates to the surface, typically develops over several years as water moves through curing concrete. This is minimal, suggesting the concrete has not been exposed to many wet-dry cycles. He pointed to the base where the concrete met the soil. The soil profile around a monument that's been in place for decades shows a characteristic compression ring and organic matter accumulation from root activity. This is absent. The soil here looks mechanically disturbed and recently consolidated. He straightened up and held the magnifying glass toward Thomas. And this copper cap style, with this particular stamping format, was not commercially manufactured before approximately 1972. So it was placed recently, Harold said. I would estimate within the last 2 to 3 years, Hess said, possibly more recently than that. He made a note. I cannot state in a legal document that it was placed fraudulently. That determination is beyond my technical scope. What I can state, with full professional confidence, is that this marker is not consistent with the claimed age of a recovered historical boundary monument, and that it cannot be used to override a monument of the age and character of the iron stake I found 71 feet to the north. That evening, sitting on Harold's porch with glasses of iced tea, Hess said, "You have a strong case. The documentary record is exceptional in 30 years of consulting work. I have rarely seen a property with this kind of continuous chain of survey evidence going back to the original federal survey. And the physical evidence supports the documentary record completely." He paused. "But I want to be direct with you. A case this strong should be straightforward. The fact that the county accepted Aldrich's survey when the original stake was locatable in 40 minutes by anyone who looked with a metal detector that concerns me." "Meaning someone didn't look," Thomas said. "Meaning someone may not have wanted to find it," Hess said. He looked at Harold over the rim of his iced tea glass. "This goes beyond a surveyor making a mistake. A surveyor of Aldrich's licensure and experience does not describe a monument as not located when a standard metal detector sweep would have found it in the first 10 minutes. He either didn't sweep, or he swept and chose not to record what he found." Harold sat with this for a moment, watching the fireflies begin to appear over his south field, small, cold lights moving through the warm summer dark above the corn. "What do I do?" he said. "Document everything," Hess said, "and find out who else Aldrich has done this to." The winter of 1987 and the spring of 1988 were the period in which Harold Benton's property dispute became something larger. His brother-in-law, George Van Sant, who had married Harold's sister Clara in 1955, and who had spent 30 years as a title insurance examiner for a Chicago firm, came to the farm for his usual Easter visit and found Harold and Thomas at the kitchen table surrounded by documents. George had made this visit every Easter since Clara died in 1983, a habit that had outlasted its original occasion and become its own thing, a connection between men who had shared a family for 30 years and found they still wanted to share a table. George sat down at the table and looked at the documents with the focused attention of a man who has spent his career finding the places where title chains go wrong. After an hour, he said, "This is a classic land fraud scheme. I've seen versions of it in Cook County and DuPage County, but never this systematically executed in a rural county." He turned a page. "The fraudulent monuments are the physical evidence, but you need to find the pattern." "Thomas is working on that," Harold said. Thomas had spent those winter months, evenings and weekends, working at the kitchen table by lamplight after his regular hours at Caterpillar, tracing the connections that Martha Gifford had pointed him toward. He had found that Philip Aldrich had filed 6 surveys in Calhoun County between 1984 and 1987. In 4 of them, the boundary lines had moved in directions that benefited the parties who commissioned the surveys. In 3 of those 4 cases, the benefiting parties had connections through Carl Whitmore or through Whitmore's law partners to Riverfront Holdings, LLC. He had also found that Riverfront Holdings had, in those same years, acquired options on several parcels of Calhoun County river bottom ground, parcels that adjoined properties whose boundaries had been revised by Aldrich surveys. "They're assembling ground," Harold said, when Thomas laid the documents out for George. "The boundary revisions give them additional acreage. The options let them buy the whole parcels if the owners decide to sell. Or if the owners are pressured to sell," Thomas said. "If a farmer's collateral has been reduced on paper because 14 acres moved off his deed, his operating loan looks different to the bank." George nodded slowly. "And if the farmer is already under financial pressure from the farm crisis, he sells," Harold said. "Or the bank takes it. Either way, the ground goes cheap." George looked at Harold across the table. "You need 2 things. A lawyer who understands real estate fraud at a level beyond county circuit court, and a regulatory complaint against Aldrich's surveying license. Because a license revocation creates a chain of evidence that invalidates every survey he's filed." "I can't afford a complex fraud attorney," Harold said. "You may not need to pay full freight," George said. "There are attorneys who take cases on contingency when the facts are strong enough." He looked at Thomas's organized folders. "These facts are strong enough." On the Monday after Easter, Harold drove to Hardin and knocked on the door of Robert Fenn, a general practice attorney who had handled wills and real estate closings and the occasional divorce for 20 years in Calhoun County. Fenn was not a specialist, but he was honest about what he didn't know, which Harold found more useful than false confidence. And when Harold laid the documents on his desk, Fenn read them with careful attention and said he would take the case on a reduced hourly fee because he found it interesting and because he had grown up on a farm in Calhoun County and understood what was at stake. The first thing Fenn did was call Walter Hess and ask him to formalize his findings in a litigation-ready report. The second thing he did was contact a colleague in Springfield, an attorney named Patricia Okafor, who handled complex real estate fraud and who, Fenn had been told by 2 separate sources, was the person you called when a case was too large for a county general practitioner to carry alone. He met Patricia Okafor for coffee in Springfield on a Wednesday in May and described the case in 20 minutes. She asked 3 questions and said she would come to Hardin the following week. Patricia Okafor was 42 years old, a former state's attorney who had spent the last 8 years in private practice handling complex real estate litigation, and she arrived at Robert Fenn's office on a Tuesday morning with a legal pad and a pen, and spent 4 hours going through every document Harold and Thomas had assembled without saying anything beyond questions. At 4 hours and 20 minutes, she closed her legal pad. "I'll take this case," she said. "Robert handles the circuit court proceedings. I handle the administrative and criminal referrals." "What criminal referrals?" Harold said. "The ones I'm going to make to the Illinois AG, the IDPR, and the U.S. Attorney for the Southern District of Illinois." She looked at Harold with the focused attention that Thomas would later describe as the most concentrated professional gaze he had ever encountered. "You've already written to some of these agencies. Last spring. I haven't heard back. You will hear back now," she said, "because I'm going to follow up on your letters personally with this evidence package, and I am going to sit in someone's office until they open a file." Harold looked at Robert Fenn, who gave a small nod. "All right," Harold said. In August of 1988, Raymond Purvis's attorney, Carl Whitmore, filed a quiet title action in Calhoun County Circuit Court, seeking a judicial declaration that the boundary between the Purvis and Benton properties was as established by Philip Aldrich's 1987 survey. This was the formal move that Harold had been expecting, the step from administrative maneuvering to direct litigation, which forced Harold to respond or lose by default. He had known it was coming. He had been walking his north fence line every week since the spring, taking photographs of the iron stake, noting its condition in his notebook, measuring its position against the fence corner posts with a steel tape. He had 17 photographs of the stake taken over the previous 14 months, each one labeled with the date and light conditions and the measurements he had taken. Robert Fenn filed a response to the quiet title action in September, attaching Walter Hess's preliminary report and requesting an evidentiary hearing on the physical evidence before the case proceeded. The hearing was scheduled for March of 1989. Harold talked to his neighbors that fall. He drove to Ed Deckard's farm on a November evening. Ed farmed 400 acres to Harold's south, a corn and soybean operation with a Citizens Bank operating note that had been renegotiated twice in 3 years. Harold spread Thomas's documents on Ed's kitchen table and explained what he had found. Ed looked at the documents for a long time without speaking. Then he said, "I had my own boundary adjusted. 1,986. 8 acres moved south." He paused. "I paid $800 for a survey that said the line was where it always was. The county used the other one. Who was your surveyor?" Ed gave a name. Not Aldrich, a different man, someone Ed had found through an advertisement in the County Farm Bureau newsletter. Harold took the survey home and Thomas looked at it on his next visit. "Ed's survey confirms his historical boundary," Thomas said. "Aldrich's competing survey moves it 8 acres south. The county used Aldrich's." He looked at the filing dates. Aldrich's was filed 4 months before Ed's. When there are 2 conflicting surveys on record, the assessor has discretion. "And nobody goes to court over 8 acres, Harold said. "Not unless they have resources and motivation," Thomas said. "And if you're already under financial pressure, you sell," Harold said. "Or you let the bank take it, and Riverfront Holdings buys the foreclosure." He drove to Frank Hollis's farm the following week. Frank farmed river bottom ground north of Hardin Good Ground, some of the best in the county, and had received 2 purchase inquiries in the past year from a company that Thomas had since traced back to Riverfront Holdings through an intermediary LLC. Frank's boundary had been revised in 1985. 6 acres, moved north. Frank had not noticed because the fence line itself hadn't moved, only the legal description in the county records. "They didn't even need to move the fence," Frank said, when Harold explained it to him. "They just needed to change the paper," Harold said. "The fence you can see. The paper, most people don't read." By December of 1988, Harold had spoken with 7 of his neighbors. 5 of them had boundary adjustments through Aldrich surveys, or surveys with connections to Aldrich's firm. 3 were under financial pressure traceable, at least in part, to the reduced collateral value of their adjusted properties. He brought this to Patricia Okafor on a Thursday afternoon and watched her write in her legal pad for 30 minutes without looking up. When she looked up, she said, "How many acres total, across all 5 properties?" Harold had the number ready. 47 acres. 47 acres of river bottom ground. She set down her pen. At current Calhoun County land values, that's approximately $940,000 in property that has been moved, on paper, from legitimate owners to positions that benefit Riverfront Holdings' acquisition strategy. The number sat in the room for a moment. "And that's just what you found?" she said. "There may be more." The evidentiary hearing in Calhoun County Circuit Court was held on a Tuesday in March of 1989 in a wood-paneled courtroom on the second floor of the limestone courthouse in Hardin. Judge Catherine Mercer, who had been on the Calhoun County bench for 12 years, presided. The courtroom was fuller than a routine boundary hearing would normally produce. Word had moved through the county in the way that word moves through small rural counties, not through announcements or newspapers, but through conversations at the grain elevator and the Farm Bureau office and the hardware store, through the specific rural grapevine that carries information about things that affect the land. Because in a county built on river-bottom farming, anything that affects property boundaries affects everyone eventually. Harold sat at the plaintiff's table with Robert Fenn. Thomas sat in the front row of the gallery. Patricia Okafor was not in the courtroom. She was in Springfield, in the offices of the Illinois Department of Professional Regulation, delivering the evidence package in person, as she had promised Harold she would do. Walter Hess testified first. He testified for 2 hours and 18 minutes. He explained the iron stake, its location, its condition, its surface oxidation pattern, its consistency with the 1,847 Federal Survey monument description. He explained the concrete marker, the efflorescence, the soil profile, the copper cap style, and the reasons for his conclusion that it was not original. He walked Judge Mercer through the 1,847 survey, the chain of documentary evidence, and the measurements he had taken that placed the historical boundary exactly where Harold had always said it was. Carl Whitmore cross-examined him for 40 minutes, focusing on the question of whether the iron stake's location had been independently corroborated before Hess's examination. Hess produced the chain of Harold's photographs, 17 images of the iron stake taken between 1,974 and 1,988, each one showing the stake in its location, each one showing no concrete marker in the vicinity. Whitmore objected to the photographs as self-authenticating. Robert Fenn responded by producing Harold's father's observation notebooks from the 1930s, 1940s, and 1950s, each one recording periodic measurements from the northwest corner stake to the fence corner posts, each one consistent with the historical boundary location. Judge Mercer admitted the photographs and the notebooks. Harold's notebooks and records were entered into evidence next. Fenn walked through them methodically, the 1,974 measurements, the 1,978 photographs, the 1,982 notation. When Harold had checked the stake after an unusually deep frost that winter, the 1,985 photographs taken when Harold had done fence line maintenance and photographed each corner stake as a record. The 1,985 photographs showed the northwest corner of the property clearly, the iron stake in its location, the fence running north from it along the property line, and in the background, visible in the wider shots, the absence of any concrete structure at the location 71 feet to the south, where Aldrich had claimed to recover a boundary monument. The concrete marker had not existed in 1985. Philip Aldrich had filed his survey in 1987. The concrete marker had been placed in the intervening 2 years. Whitmore objected that the photographs did not definitively prove the absence of a marker. Perhaps it was obscured, perhaps the angle was wrong. Robert Fenn asked Harold to take the stand. Harold testified for 40 minutes. He described walking the fence line every spring and fall for 40 years. He described the specific characteristics of the northwest corner, the limestone outcrop, the drainage pattern, the location of the corner post relative to the stake, in the particular detail of a man who knows a place the way he knows the inside of his own house. He testified that he had never, in 40 years of regular observation, seen a concrete structure of any kind at the location where Aldrich's marker stood. He was not a dramatic witness. He did not speak with the practiced ease of someone accustomed to courtrooms. He spoke in the same measured, unhurried way he spoke everywhere, the voice of a man who says what he knows and stops when he reaches the edge of what he knows, which Judge Mercer would later note in her ruling was itself a form of credibility. Philip Aldrich testified in the afternoon. He was a compact man of 60 in a pressed shirt, and he had the particular confidence of a professional who has not been seriously challenged on his work in a long time. He stated that the iron stake had not been visible when he conducted his survey, that the concrete marker was a legitimate recovered monument, and that his survey represented his professional judgment. Patricia Okafor had driven from Springfield and arrived at the courthouse at noon. She cross-examined Aldrich for 55 minutes. She established that Aldrich routinely used a metal detector for monument searches on surveys involving historical properties. She established that a standard metal detector sweep of the Benton northwest corner area would have located the iron stake within the first few passes. She established that Aldrich's field notes from the Benton survey contained no record of metal detector use at the northwest corner. She asked Aldrich to describe the efflorescence pattern on the concrete marker and explain how it was consistent with a monument of claimed historical age. He described it in general terms. She produced Walter Hess's detailed analysis of the efflorescence, with photographs, and asked Aldrich to explain the discrepancy. He said that environmental conditions varied. She asked him about the copper cap. He said that older caps of similar style existed. She produced documentation from 2 copper cap manufacturers, establishing the introduction dates of the style used on the Aldrich marker. Neither manufacturer had produced that style before 1973. Then she produced the telephone billing records. She had obtained them through a discovery subpoena filed 3 weeks earlier in the quiet title, "Action Billing Records Were Producible in Civil Discovery in Illinois Circuit Court Proceedings," and Fenn had filed the subpoena as a matter of course when the litigation began. The records showed 11 telephone calls between Aldrich's office number and Carl Whitmore's office number in the 8 weeks before Aldrich's survey of the Benton property was conducted. Aldrich said he had consulted with Whitmore only about standard procedural matters related to the survey filing. Okafor asked him to identify which of the 11 calls concerned which procedural matters. He said he could not recall the specific content of each call. She asked him whether, in any of those 11 calls, Whitmore had described to him the desired outcome of the boundary determination. He said no. She looked at him for a moment with an expression that contained no emotion, not disbelief, not contempt, simply the focused attention of a person who has recorded an answer and will decide later what to do with it. "No further questions," she said. Judge Mercer issued her ruling in May of 1989. She found that the Aldrich survey was not entitled to presumptive weight in the boundary determination because of substantial credible evidence that the claimed recovered monument did not predate the survey and may have been placed in anticipation of the survey. She further found that the original 1,847 iron monument, whose presence, location, and condition were established by an unbroken chain of photographic and documentary evidence spanning 27 years, was the controlling monument for the boundary determination. The boundary between the Benton and Purvis properties was, as Harold Benton had always maintained, located at the historical iron monument, 14 acres. Back in the deed, Harold read the ruling standing at the kitchen table. He read it twice, which was once more than he needed to understand it, and once less than he had been prepared to need. Then he folded it and put it in the folder labeled Deed and Survey between the 1,847 plat and the 1,962 deed, where it seemed to belong. He called Thomas. "We won," he said. Thomas was quiet for a moment. "How do you feel?" Harold thought about this honestly, which was the only way he thought about things. "Like a man who just got back what was always his," he said. "Not better than that. Not worse." He put on his boots and went out to the north field in the May afternoon and walked the fence line, the full line, from the southeast corner to the northwest corner the way he walked it every spring. He stopped at the northwest corner and looked at the iron stake, sitting in the ground where Cyrus Benton had driven it in 1847, 18 inches above the soil in the afternoon light. He did not say anything to it. He was not a man who talked to iron stakes, but he stood there for a while, in the way that a man stands at a place that has cost him something to keep. The circuit court ruling was the first result. It was not the last. Patricia Okafor had kept her promise about the regulatory complaint. She had delivered the evidence package to the Illinois Department of Professional Regulation in March 1989, during the same week as the evidentiary hearing, and had sat in the office of an IDPR investigator named Gerald Marsh for 3 hours, walking through the evidence systematically. Marsh had opened a formal investigation the following week. The IDPR investigation took 14 months. In August of 1990, Philip Aldrich surrendered his Illinois surveying license as part of a consent agreement with the Department of Professional Regulation. The agreement found that he had placed or caused to be placed survey monuments at locations inconsistent with historical boundary evidence in at least 3 surveys in Calhoun County and 1 survey in Pike County. His license was revoked permanently. He was required to pay restitution to the affected property owners, amounts that varied by case, in total approximately $42,000, and was prohibited from performing any surveying services in Illinois under any arrangement, including as an employee or subcontractor of a licensed firm. The license revocation was published in the Illinois Register and reported in the regional legal press, which was how Carl Whitmore learned about it on a Tuesday morning in August while reading The Street Louis Post-Dispatch over his breakfast. He called Raymond Purvis immediately. Raymond, to his credit, or perhaps simply to his instinct for self-preservation, called his own attorney not Whitmore, but a criminal defense attorney in Street. Louis named Andrew Pratt before he returned Whitmore's call. Patricia Okafor had also kept her promise about the federal referral. She had delivered the evidence package, with a cover letter she had spent 2 days drafting, to the U.S. Attorney's Office for the Southern District of Illinois in the same week as the IDPR complaint. The assistant U.S. attorney, who received it, a man named David Park, who was 34 years old and had been in the U.S. Attorney's Office for 6 years, and who had been looking for a substantial rural real estate fraud case for the previous 2 of those years, read the evidence package in a single sitting and opened a preliminary inquiry. The federal investigation moved more slowly than the state proceedings, for reasons Harold understood and accepted without particular frustration. Federal investigations are large machinery, and large machinery turns at its own pace. What Harold knew, by the spring of 1990, was that the following things had happened, or were happening. His 14 acres were back in the deed. Ed Deckard's 8 acres were back in the deed, resolved through a separate circuit court proceeding, using Harold's documentation framework at substantially reduced legal cost because the groundwork had already been established. Frank Hollis's 6 acres were back in the deed through the same process. 2 other affected neighbors had initiated similar proceedings with Robert Fenn's assistance. Philip Aldrich no longer had a surveying license, and a federal investigation was open into Riverfront Holdings LLC, Carl Whitmore, and Raymond Purvis. He planted his corn in April and his soybeans in May, and he walked his fence lines the way he always had, and he kept his notebooks. The federal investigation concluded in the spring of 1993, 4 years after Harold's circuit court ruling, 6 years after the letter from Douglas Crane's office. The U.S. Attorney's Office charged Carl Whitmore and 2 associates with wire fraud, mail fraud, and conspiracy to commit real estate fraud. The indictment alleged that Whitmore had coordinated with Philip Aldrich to produce fraudulent surveys, had used those surveys to manipulate county property records across Calhoun and Pike counties, and had used the resulting artificial reduction in property values to facilitate the acquisition of agricultural land at below-market prices through Riverfront Holdings and associated entities. The indictment described a scheme that had affected, in total, 11 properties across 2 counties, with an aggregate fraudulent boundary adjustment of approximately 112 acres of agricultural land valued, at the time of the fraud, at approximately $2.1 million. Raymond Purvis was named as an unindicted co-conspirator. His attorney, Andrew Pratt, had negotiated a cooperation agreement in which Raymond provided testimony and documentary evidence about the scheme's origins and financing in exchange for immunity from prosecution. Raymond's cooperation was, by the federal prosecutor's account, substantial. He had kept records of his communications with Whitmore, including written summaries of their conversations about Aldrich surveys, which Whitmore said apparently not known existed. Carl Whitmore pleaded guilty to wire fraud and conspiracy in November of 1993. He was sentenced to 4 years in federal prison and ordered to pay restitution of $1.8 million, an amount his attorney argued he could not fully pay, and that was, in fact, never fully paid. But that formed a legal judgment that followed Whitmore through the next 2 decades of his life. Philip Aldrich, who had already surrendered his license and paid his state restitution, was charged separately with making false statements on federal land records. He pleaded guilty to a misdemeanor count and received 3 years probation and a fine of $25,000, which his attorney successfully argued was appropriate given his cooperation and the relatively minor criminal history. Harold thought the sentence was too light. Patricia Okafor agreed with him, but explained that Aldrich had cooperated fully with both the state and federal investigations, and that cooperative witnesses receive benefits regardless of how one might feel about the fairness of that arrangement. Douglas Crane, the Calhoun County Assessor who had accepted Aldrich's surveys and applied them to the county records without the verification that his office was required to perform, was not charged with any crime. He resigned from the assessor's office in the fall of 1990, 3 months after Aldrich's license revocation became public. He gave no statement to the press and no explanation to the county board. He simply stopped coming to work and submitted his resignation in writing. The investigation never produced evidence sufficient to establish that Crane had been a paid participant in the scheme rather than simply a negligent official who had been manipulated by more sophisticated actors. Harold thought about Douglas Crane occasionally over the years that followed, not with anger, which had never been his primary emotion about the situation, but with a kind of bemused clarity. A man in a position of public responsibility had failed to do the basic work of verification. He had accepted a document produced by someone with an interest in the outcome without checking whether the underlying facts supported the document. The consequences of that failure had fallen, for years, on the people whose property he was supposed to protect. The iron stake had been there the whole time, 40 minutes, and a metal detector. By the fall of 1993, when Carl Whitmore was entering his guilty plea in the federal courthouse in East Street, Lewis, Harold Benton was 67 years old and farming the same 240 acres he had always farmed. He had spent, by Thomas's accounting, approximately $22,000 on legal fees over the 6 years of proceedings, amounts paid to Robert Fenn and Walter Hess, with Patricia Okafor's work covered through a contingency arrangement that entitled her to a percentage of any monetary recovery. The monetary recovery, when the restitution payments were eventually distributed, amounted to approximately $11,000 for Harold directly partial reimbursement for legal costs and the estimated value of the use of the 14 disputed acres during the period of the dispute. Thomas had pointed out that this meant Harold was approximately $11,000 out of pocket from 6 years of litigation. Harold had said that the alternative was being 14 acres short for the rest of his life, and that the arithmetic of that alternative was considerably worse. What Harold could not quantify, and did not try to, was what the 6 years had cost in other ways. The winters of working through documents at the kitchen table, when he should have been resting between harvest and spring planting. The weight of a legal dispute that lived in his mind during the quiet hours of farming, during the long straight rows of planting and cultivating and harvesting, when there is nothing to do but think. The awareness, every time he looked at his north fence line, that someone had tried to take what was his and had nearly succeeded. These costs were real but not calculable, And Harold was not a man who spent much time calculating things he couldn't change. What remained, on the other side of the accounting, was this: his land was intact. His neighbor's land was largely intact. The mechanism that had been designed to strip agricultural ground from a generation of farmers who had survived the 1980s farm crisis was documented, prosecuted, and at least partially dismantled. And the evidence that had made all of this possible was not a computer or a GPS system or a piece of precision technology. It was a handwritten notebook, a steel tape, a camera purchased for photographing crop disease, and a knowledge of his own ground that Harold Benton had acquired by walking it, season after season, for 40 years. Thomas came home for Christmas of 1993 and found his father at the kitchen table with a glass of whiskey. A rare enough occurrence that Thomas registered it as significant, and a copy of the newspaper account of Whitmore's sentencing. "How are you feeling about it?" Thomas said. Harold set down the newspaper. "I'm feeling like it's over," he said. "Is that good?" Harold considered the question seriously, the way he considered all questions. "It's better than the alternative," he said, which was it not being over. Thomas sat down across from him. The kitchen was the same kitchen it had always been, the same table, the same chairs, the same window through which you could see the machine shed and, beyond it, the north fence line and the dark December fields. "I've been thinking," Thomas said. Harold waited. "I've been thinking about coming back." Harold looked at him. "Not full time," Thomas said quickly. "I'm not the farm can't support 2 families. I know that. But Caterpillar has been talking about a position in Decatur. That's an hour from here. I could," he stopped. "I don't want to walk into this place in 20 years and not know where the survey stakes are." Harold was quiet for a moment. "You know where the stakes are," he said. "You found them." "I found them because you showed me what to look for," Thomas said. Harold picked up his whiskey glass and looked at it for a moment. Outside, the December wind moved through the cottonwoods along the drainage ditch, a sound Harold had heard from this kitchen for 60 years, a sound that was part of what this place was. "The Decatur position," Harold said. "Would it be good work?" "Good enough," Thomas said. "Different from what I'm doing, but good enough." Harold nodded slowly. "Then you should take it," he said, "if you want to come back." Thomas took the Decatur position in February of 1994. He drove to the farm every other weekend and spent most Sundays helping with whatever needed doing, equipment maintenance in winter, field work in spring and fall. He had his own apartment in Decatur and his own life separate from the farm. But he walked the fence lines with Harold in the spring and fall, and Harold showed him things that couldn't be written down. The way the drainage tile sounded when you put your ear to the inspection pipe, the particular color of the corn leaves in the northeast corner that meant moisture stress before any instrument could confirm it, the location of every survey stake on the property, and the history of each one. In the spring of 1994, they walked the fence lines together, the May afternoon warm and the fields just planted, the cottonwoods along the drainage ditch in their first full leaf. They stopped at the northwest corner stake, as Harold stopped every spring, and looked at it. "Your great-great-great-grandfather drove that stake," Harold said. Thomas crouched next to it and put his hand on the iron. It was cold from the soil, solid, unmovable. "How long will it last?" Thomas said. "Iron in limestone doesn't rust the way iron in clay does," Harold said. "It'll be there when you're my age." He paused. "Longer, probably." Thomas stood up. They looked at the stake in the spring light, the faded orange of old oxidized iron, the same color it had been in every photograph in Harold's notebooks going back to 1974. "I need to start my own notebook," Thomas said. Harold looked at him. It was not a smile, exactly. Harold's face did not move easily towards smiles, but something in it shifted, the way a field shifts color when a cloud moves off the sun. "There's a blank one in the desk drawer," he said. "The same kind I use." The Calhoun County land records were revised and corrected through a process that took the county assessor's office under new leadership, a woman named Sandra Wilkes, who had been appointed after Crane's resignation 3 years to complete. All 11 properties affected by fraudulent Aldrich surveys were restored to their historical boundaries. The county revised its survey acceptance procedures to require independent verification of any newly filed survey that conflicted with historical monuments, a procedural change that Sandra Wilkes implemented in 1991 and that remained in force through the subsequent decades. Robert Fenn retired from law practice in 1998, having handled, by his count, more property boundary cases in the last 10 years of his career than in the previous 20 combined. He told Harold at his retirement party that the Benton case had changed how he thought about rural property law and about the value of documentation that he had. After the case concluded, started advising every farm client he had to photograph their survey monuments annually and keep the photographs in a fireproof location. Walter Hess retired from the University of Illinois in 1995 and wrote a monograph on fraudulent survey monument placement that was published by the Illinois Society of Professional Land Surveyors and used as a training document in geodetic engineering courses for the following decade. He sent Harold a copy with a handwritten note that said, "The iron stake was the argument. Your photographs were the proof. Between the two of them, the rest was inevitable." Martha Gifford retired from the Calhoun County Recorder's Office in 2001 after 36 years. Thomas attended her retirement party and brought her a framed print of the 1,847 Benton survey plat, which she hung in her living room next to a photograph of her grandchildren. Patricia Okafor continued to practice complex real estate fraud law in Springfield. She took 3 more rural land fraud cases in the decade after the Benton case and won 2 of them. The third, a case in a southwestern Illinois county where the scheme had been operating for nearly a decade before anyone noticed, ended with a settlement that she considered inadequate, but that her client, an elderly widow of 74, accepted because the years of litigation had cost more than she could bear. Okafor thought about that case for a long time after. Harold Benton died in the spring of 2001, at the age of 75, of a heart attack that happened in the East Field during the second week of May, the planting week, his favorite week of the year, the week when the soil was warm and the seed, corn went in, and everything that the coming season would be was still possible. He was found by Thomas at 7 in the evening, when Harold had not come in for supper, and Thomas, who had driven out from Decatur for the weekend's planting work, went looking for him. He was sitting against the rear tire of the John Deere 4020, his cap on his knee, looking east across the planted rows toward the river. Thomas thought, for one moment, that he was resting. The funeral was held at the First Lutheran Church in Hardin, and the attendance was the kind that a man receives when he has lived in a place for 75 years and conducted himself in a way that the place remembers. Farmers came who Harold had helped, and farmers came who had simply known him. Ed Deckard came, and Frank Hollis came, and 7 other men and women whose property boundaries were what they were, partly because of what Harold had done. Robert Fenn came. Walter Hess drove down from Champaign. Martha Gifford sat in the 4th row with her husband and cried in the quiet way of someone who does not want to be noticed crying. Patricia Okafor sent flowers and a handwritten note that Thomas kept. The note said, "Your father understood something that most people never learn, that the evidence you gather when nothing seems wrong is the only evidence that's useful when everything goes wrong." The notebooks he kept for 30 years before the dispute began were worth more than anything I could have done for him in a courtroom. I've been telling that to clients ever since. Thomas stood at the graveside in the May afternoon and listened to Pastor Hendricks read from the book of Ruth, "Whither thou goest, I will go, and where thou lodgest, I will lodge," and thought about the kitchen table and the documents spread across it and his father's handwriting in the margins of the legal pad, precise and unhurried, recording what he knew. He drove back to the farm that evening and walked the fence lines in the last of the light, the way Harold had always walked them in the evenings of late spring. He stopped at the northwest corner stake and crouched next to it and put his hand on the iron, the way he had in 1994. Cold, solid, unmovable. He went back to the house and got the notebook from the desk drawer. His own notebook, started in 1994, 7 years of observations in his own handwriting, and wrote the day's date and the weather conditions, and the condition of the survey stake. Is weather is a start of sea, that is not side. Day's weather conditions. Is weather cleared of the survey, the way Harold had written the same things for 39 years before him. In the spring of 2024, Thomas Benton was 66 years old and farming the same 240 acres his great-great-great-grandfather had claimed in 1847. He had retired from Caterpillar in 2012 and moved to the farm full-time, which was a transition that happened gradually and then completely, the way important transitions often happen. He had hired a neighbor's son named Kevin Marsh to help with the heavier work. Kevin was 28, grew up on a farm 2 miles away, and had the particular attentiveness that comes from being raised around machinery and soil and the specific rhythms of agricultural seasons. The farm had a GPS guidance system on the planter now and a yield monitor on the combine, and Thomas used both with the appreciation of a man who understood their value and had never claimed they were useless. The GPS told him things about his fields that he genuinely could not see otherwise. The yield variation across the east field, the moisture patterns that had always felt like intuition but now had coordinates attached to them. But he also walked the fence lines every spring and fall, the way Harold had walked them. And he kept his notebooks, and he knew where every survey stake on the property was located and when it had last been checked and what it looked like. He had taught Kevin Marsh to do these things over 3 seasons, not as a formal lesson but in the way Harold had taught him by doing them together, by stopping at each stake and explaining its history, by pointing out the landmarks and the measurements and the chain of documentation that connected a square iron rod in the ground to a plat filed in a land office in Hardin on a Tuesday morning in September of 1847. Kevin had listened with the attention of a young man who understood that he was being given something worth having. In the spring of 2024, a developer named Hartwell Properties, LLC, a company incorporated in St. Louis, as it happened, filed for a variance with the Calhoun County Zoning Board to develop a section of river-bottom ground along the Illinois River for a recreational marina and associated commercial development. The filing included a survey of the proposed development boundary that, when Thomas examined it, showed a line that crossed into the northeast corner of the Benton property by approximately 30 feet. Thomas went to the county recorder's office on a Monday morning with his notebooks and his photographs, and the 1,847 plat, and the chain of deeds, and the record of the 1,989 circuit court ruling, and Walter Hess's survey report, all of it organized in labeled folders in a document box. He met with the county recorder, a man named James Wilton, who had been in the position for 8 years, and laid the documents out on the reading table in the same basement room where Thomas had worked through the records in the summer of 1987, under the same flickering fluorescent light. Wilton looked at the documents. He looked at the survey filed by Hartwell Properties. He looked at the 1,989 ruling. He looked at Thomas. The Hartwell survey shows their line crossing your northeast corner, Wilton said. By 30 feet, Thomas said. My survey stake is at this location. He pointed to the coordinates on the 1,847 plat and the 1,989 survey. Their line crosses it here. Have you been out to verify the stake recently? Thomas produced a photograph dated 3 weeks earlier, showing the northeast corner stake in its location, with a measurement tape running from it to the fence corner post. He produced the same photograph from the previous fall, and from the spring before that, and from 5 years earlier, and from 10 years earlier. Wilton studied the photographs. I'll flag the variance application, he said. They'll need to address the boundary question before the zoning board can proceed. Thomas nodded and put his documents back in the folder. He thanked James Wilton and drove back to the farm. He stopped at the northeast corner of the east field on his way in. The survey stake was where it had always been a square iron rod, 3/4 of an inch across, standing in the ground at the edge of the field, its surface carrying the dark reddish-brown oxidation of iron that has been in the soil for a very long time. He took a photograph, labeled it with the date and the weather conditions and the measurements he had just taken with the steel tape from the stake to the fence corner post. Put the photograph in the folder. Put the folder in the document box. Put the document box back in the desk drawer. Wrote in his notebook. Northeast corner stake present and undisturbed. Measurement to fence corner post consistent with historical record. Hartwell Properties variance flagged by county recorder pending boundary resolution. Closed the notebook. Outside, the April light came through the kitchen window, at the angle it always came at this time of year, the particular, purposeful angle of Illinois spring light that tells a farmer the ground is warming and the planting window is opening and the season is beginning again, the way it has always begun, the way it will always begin, as long as there is someone here to notice it. On the back wall of the machine shed, beside the pegboard where Harold had kept his spare parts, and where Thomas now kept his own organized inventory of belts and bearings and blades, there is a wooden frame containing two things side by side under glass. On the left, a photocopy of the 1,847 Federal Survey plat for the Benton property, showing the original township and range coordinates, and the description of the northwest corner monument, an iron rod, driven to the limestone in the surveyor's script of 177 years ago. On the right, a photograph taken in the spring of 1994 by Thomas Benton, showing his father Harold standing at the northwest corner of the east field beside the iron survey stake, his hand resting on top of it, his face turned slightly away from the camera toward the field, wearing the expression of a man who is looking at something that belongs to him and has always belonged to him and will belong to whoever comes after him, as long as whoever comes after him knows where the stakes are and takes the trouble to look. Below the frame, written on a card in Harold's handwriting from the last year of his life, is a single line. The land remembers what the paperwork forgets. Walk your lines.